Number 92, People v. Lance Williams. Counsel?
Good afternoon. John Briggs from Davis Polk and Wardwell on behalf of Appellant Lance Williams. I'd like to request 2 minutes for rebuttal.
2 minutes, thank you.
May it please the court. The trial court should have charged temporary lawful possession. The evidence viewed in the light most favorable to the defendant showed, first, the possession was temporary. It lasted less than a minute. Second,
How is it lawful? Because there they were, they're in the stairwell, and his friend gives him the gun. Why couldn't he have just said, I don't want it, or turned around and gone back up the stairs? What was occurring at that moment that made his possession lawful?
Your Honor, this was a rapidly unfolding situation where the defendant was in imminent danger, and he reasonably believed that he was in imminent danger.
Didn't he place himself in that imminent danger? Foe opened the door, looked out, saw the other guy, and he barges in.
Well,
how is that lawful?
Judge, for the entire time of this encounter, the defendant was trying to escape to a place of safety. He went upstairs to Foe's apartment. He asked if he could stay there. Foe and his girlfriend refused that. Foe and his girlfriend...
It was a 21-story building, right? And there were a lot of other places, presumably. Was there any indication that this guy was coming up to look for him or anything?
Well, the defendant didn't know whether Carson was coming up to look for him. The only thing that he knew was that Carson had followed him in the direction of the building, had pulled out a gun upon seeing him. And I would suggest to Your Honor that the question is not whether there was anything else that Williams could have done at some previous point, but the question is at the moment that he accepts possession of the weapon. Was it at that point, was he in imminent danger? Did he reasonably believe he was in imminent danger?
How are you, to her, Judge Stein's point,
Judge Feynman.
How are you, over here, sorry. To Judge Stein's point, how are you in imminent danger if you're behind a closed door in a stairwell with a route of escape?
Well, he was in imminent danger because Foe was leaving into the lobby. At that time, they knew that Twin was in the lobby. They believed and had every reason to believe that Carson was likely in the lobby. And I think it parses it too finely to say that there would be no imminent danger if Foe opened the door and somehow Williams didn't perceive that.
But aren't you essentially arguing that he had it for his protection before he went into that area, self-protection? And haven't we said that that's not a basis for legal possession?
Your Honor, we don't disagree with the cases about arming oneself for one's protection, but we don't believe that that's applicable here. Those cases, including the Carrion case that my adversary cited, are cases in which there is a period of time when the defendant was in a safe position and then perceived that there would be some future time when they would get into an altercation with an adversary. They were worried about some future event. Here, in contrast, it was mere moments between when Foe handed Williams the weapon and when Williams was confronted, as he was expected to be, by Carson in the lobby. There was no period of time unfolding.
Most of the cases that find that there is temporary and legal possession, don't they relate more to a situation where there's already an ongoing attack, where there's a justification defense, and the defendant grabs the weapon from the attacker, that kind of situation where they're really in the midst of it, not where there is, as Judge Feynman indicated, an opportunity to walk away before the danger is even there.
Well, Judge, I would submit that a reasonable view of the evidence was that this was an ongoing emergency. It was a situation where the defendant was trying to escape from imminent danger. And I would also suggest that the cases do not require that the source of the danger be the source of the weapon. There are numerous cases where a defendant has had temporary lawful possession and they obtain it from somebody else, as in this case, or it's in the environment. They pick a weapon off the floor. And that's entirely consistent with
The
temporary lawful
problem is,
possession.
I guess, the problem with that analysis, just to follow up on Judge Stein's questions, is the way I understand the CJI charge on temporary lawful possession is it maintains possession, it's two parts, and attains possession in an excusable manner and maintains possession only long enough to dispose of it safely. Well, it clearly doesn't meet the dispose of it safely prong of it, but in a self-defense analysis, where the charge is given for justification, I guess I'm struggling with the difference between having a gun legally or else having an illegally obtained gun that you used in a legal manner. Do you see a distinction there in what should be charged?
Well, Your Honor, I'll try to address that. First, to one of your earlier arguments, I would say that actually there was safe disposal, or at least there was disposal here that was consistent with the manner in which the weapon was lawfully obtained. And to the point about whether the weapon was lawfully obtained, we believe that it was. This was a situation where at the moment he receives the weapon, events were rapidly unfolding, and he had every reason to believe that if he did not take that weapon, he would be a sitting duck for Carson. So, we think that it was completely appropriate and lawful under the circumstances and under this court's cases involving situations where a weapon is obtained in self-defense or at a moment where self-defense is, imminent and it's about to happen. And that's what happened here. And we would add that the First Department's rationale that the weapon was not used in a lawful manner, is simply inconsistent with the undisputed fact that everybody agreed that the jury got a justification charge here. So there's a reasonable view of the evidence that the supposedly dangerous use here was consistent with justification, and we don't think that there's any support in the case law for a justified use of the weapon being the type of use that deprives the jury from considering temporary lawful possession.
But you don't know that I understand they got the charge, but you can't read into the verdict anything about whether it's because they didn't think it had been disproved beyond a reasonable doubt, as they have to, the prosecution has to do, or because they accepted that, or there's some other. There aren't specific verdicts or specialized verdicts in criminal cases, so we have no idea why they acquitted on these other charges.
Well, we don't need to know why the verdict of acquittal happened on the other charges. What we need to know, and what we do know, is that the evidence, a reasonable view of it, based on the defendant's testimony and corroborated by other evidence of the trial, was in support of justification. So a jury reasonably could find justification.
I guess my question would be, certainly the fact that there was a reasonable basis view of the evidence to support that charge, the charge of justification, doesn't mean that automatically that the separate question of whether not the use of the weapon, but the obtaining and the possession of the weapon was voluntary. I'm sorry.
I agree that the justified use is not dispositive of the issue of whether it was lawfully obtained at the beginning, but we do think that under these circumstances, the situation was very much akin to other situations where a defendant is under attack and receives a weapon, at a time of imminent danger, and then uses the weapon lawfully.
So what if I'm in my house and I see someone directly across the street, or maybe at the end of my driveway, that I have some history with, and maybe that person has threatened me in the past, I don't know. And I have no evidence that he's trying to get into my house or that he's approaching my house or anything of that nature. And I have a gun, and I don't own it legally. I don't have a permit for it. And I decide, you know what? I'm afraid this guy is going to do something bad to me. And I'm just going to go out, I'm going to open my door, and he's there, and I'm going to shoot him.
Well,
How is that different from self-protection?
Well, I think that hypothetical, maybe would have some problems with temporary lawful possession.
So what's
We have-
different between that hypothetical
I
and the situation here?
I think there are at least two things that are different, Your Honor. I think first, that's a situation where you have the ability to safely retreat, and in that scenario.
So we may disagree on whether the defendant here had that ability. But if we find that he did have that ability, is that dispositive?
Well, I think that finding should have been a question for the jury. But this is a situation.
Well, it wasn't. Could the jury have reasonably found that there was an opportunity to retreat? But my question to you now is, if that is the conclusion we reach, is that dispositive?
Well, the question for Your Honor should be whether there's any reasonable view of the evidence, that shows a reason to deprive the instruction of temporary lawful possession.
You're right. It's better phrased that way. So if we find that there is no reasonable view of the evidence that he did not have the ability to retreat, then is that dispositive?
Well, I think that would be a substantially harder case. But this is a case where the question of the ability to retreat was actually before the jury on justification. And this is a case where viewing the evidence in total, at the time that the weapon is received, a jury could reasonably find that his option, was either to take the weapon or to be in the stairwell in an unfamiliar building when Foe is about to open the door and does immediately open the door and enter the lobby where he knows that Twin is and reasonably believes that Carson is. So, we think that at least as a matter of law, this court cannot conclude.
So I just want to close this up. You're suggesting that because the weapon is used in a justified manner, that the weapon cannot also be used in a dangerous manner, which is, this other part of the appellate division's rationale. But can't you be justified in acting and using force in self-defense and at the same time be handling the weapon in a reckless manner?
Well, I suppose there might be circumstances, in which that would be the case, but we don't think that that's the circumstances here. And we do think that the fact that a justification.
So you don't think that conclusion by the appellate division has any support in the record?
No, we don't. The appellate division selectively parsed the record in a way that a jury viewing the evidence in the light favorable to Williams would not have had to conclude.
When we look at that conclusion by the appellate division, what standard do we use to review that?
I think the evidence, whether a reasonable view of the evidence, if the evidence is viewed most favorably to the defendant, is whether there was some sort of dangerous use. But I would add, Your Honor, that would have to be some sort of use that is separate from the issue of the action that was, justified under these circumstances.
Thank you, counsel. You'll have your rebuttal. Go ahead.
Good afternoon. I am David Slott from the Bronx County District Attorney Office for the respondent. May it please the court. This case is unlike many temporary lawful possession cases where a defendant either finds a gun or disarms a would-be attacker. Here, the defendant initially and unlawfully...
Is that necessary?
No, Your Honor, it's not. Just in terms of the broad overlook of all the case law, these are primarily the sort of rules that we're looking at. And it boils down to two things, two prongs that the defendant must satisfy in order to get this instruction. First, there must be a lawful excuse for taking possession, and second, it must not be used in a dangerous manner. And I'll talk about both of those. because here defendant initially and unlawfully armed himself in anticipation of a potential confrontation, and then his actions once he obtained the possession, recklessly entering a crowded building, blanking out, firing 5 shots, shooting 2 people, these actions were utterly at odds with a claim of innocent possession. So turning to the lawful excuse, it requires an actual imminent threat. That is key. And the possession crime happens in the stairwell, if not earlier, and I addressed that in the brief, but
So if he and Foe had walked into the lobby, he then had seen Carson and saw Carson reach for a gun, he would have been justified, in your view, of grabbing the gun from Foe and shooting?
I believe you said if, correct?
If.
Yes, I would
If.
agree, he would, that would be a lawful excuse
Temporary
for
lawful.
taking possession, that first prong, yes.
Okay.
But of course, that didn't
didn't
happen.
happen.
Of course. So the defendant, when he did take possession of the gun, and he was explicit in his testimony that he was taking it for his protection, that he knew it was loaded, and he planned on using it if he saw Leon. When he took that, there's no inference to be drawn, there's no competing set of facts. The defendant was crystal clear at least a half dozen times during his testimony that he did not know where Leon Carson was when he took that gun. And it boils down to this.
Well, so let me ask about that then.
Yes,
Suppose
Your Honor.
what happened is Foe sticks his head out, looks and sees Carson there and sees that Carson has a gun, ducks back in and says, Carson's out there and he's got a gun. Is that enough?
That's a much closer.
Yeah, that's what I'm asking.
I agree. That's much closer. It leads to the question of,
What I'm pushing on is it knowledge that you're focusing on? Knowledge of the threat? Or can it be secondhand knowledge? How much of an inference can it be?
knowledge is an important element. I'm not sure I would say it's the end-all, be-all, but there are many competing elements here, and it wasn't reasonable for him to believe that Carson was in the lobby, because it boils down to this, that he, defendant, took possession of this loaded weapon because he was told there's a man in a blue jacket in the lobby. That's it. That's it. And there's some presumption, and he starts to presume in his own testimony that that man in the blue jacket is the individual known as Twin. But defendant doesn't know Twin. Foe doesn't know Twin. There was only a mention of Leon being with, whatever that means, a dude in a blue coat, a hoodie. And then he's told there's a man with a blue jacket in the lobby. And so automatically thinks that must be Twin, that Twin must be with Leon, that Leon is lying in wait with this loaded weapon. There's no imminent threat there. That's far too low a threshold to permit somebody to take possession of the weapon. There is no lawful excuse based on that. So,
But doesn't that, what you've just described, have to be considered in light of the history between these men?
I agree.
And what had been observed before then? When he sees them, when he's coming back, and when he runs up, right?
I agree the history is potentially an element, and if you see somebody, the hypothetical that Judge Stein gave, that you see your nemesis, if you will, out your window, it's a little different because you're seeing them out your window. In this case, the defendant saw Carson, and this is the first time he's seen him in 5 years, mind you. He sees him outside the building for about 5 seconds, at which point the defendant goes back into the building, and there's a period of 7 minutes before he sees him. And the next time the defendant sees Leon Carson, the defendant has a gun in his hand, and he's shooting the gun, blanking out, not recalling what's happening, because he can't recall whatever is on the video. But the defendant didn't even know that Carson walked into the building. As the trial court said, he could have been 5 miles away. 7 minutes had passed. So, yes, all these things are possible, but even the light even looking in the light most favorable to the defendant, we can't stack inference on top of inference on top of inference to get to whatever logical conclusion defendant is looking for in order to get this instruction. The second prong.
So just to be clear, in
Yes.
your view, when the gun is thrown to him, in your view, what is it he understands is happening in that moment? Based on the
said-
testimony, the evidence, the position the people have taken.
He says he believes Leon Carson is in the lobby, that he needs to take this gun for protection. He's asked over and over again and admits, I do not know that Leon Carson's in the lobby. I believe he does. And so I'm taking this gun for my protection, and I'm going to use it if I need to, if I see him. And so just based on that, his initial possession of this gun is unlawful.
So your reading is that he actually, when he gets possession of the gun, is not committed to using the gun, doesn't know that he'll ever need the gun, because, as you argue, he doesn't know that Carson is even there.
He's arming himself.
Is that?
Yes, and he's arming himself in anticipation of a potential confrontation. And it could be a scenario where Leon Carson's not in there, and the defendant just takes the gun for his protection out into the lobby, outside the building, to his car, and then hands it to Foe. That, likewise, is not temporary lawful possession. So the fact that he later uses the gun for self-defense can't retroactively excuse possession of the gun that was unlawful from its inception. And that brings me to the second prong, either of which, if we convince this court on either of those points, the appeal should fail. The dangerous manner element requires looking beyond the mere use of the weapon. And the use of the weapon in this case, I'm talking about the firing of the weapon, right? This court's precedent has always looked at the surrounding circumstances to determine whether or not the defendant's actions are utterly at odds at a claim of innocent possession. There's cases like Snyder and Banks where the weapon was not fired, yet this court determined that concealment of the weapon, failure to turn it into the police, that failed the dangerous manner prong. So here, the use of the weapon is more than simply firing it. It includes the circumstances before and after shooting. We can't simply say this shooting was justified, which we don't argue it is. So the dangerous element is satisfied, and appellant just agreed to that. So the dangerous act here, in addition to shooting in a very small lobby that was crowded with 5 other people, is simply taking this loaded weapon into the lobby where he believes his nemesis is, who's armed and waiting for him. So simply.
Counsel, is there any significance to the fact that he gave the weapon back to Foe and then fled the scene? Does that fit into this analysis at all?
Yes, and that's sort of looking at the surrounding circumstances after the use of the weapon. Him throwing it to Foe after was to get rid of this gun that was just used in a shooting, to ensure that the police don't find it, to conceal it from any authorities, which has in fact happened. This gun was never recovered. It wasn't presented in evidence at trial. So yes, throwing your gun to a co-illegal possessor is utterly at odds with a claim of innocent possession of this weapon. Yes, absolutely. So this court, and I urge this court to consider, when considering the surrounding circumstances of defendant's conduct, we should look whether or not, or factor whether or not the defendant recklessly or negligently placed himself in a situation where it was probable that he had to use this weapon. So the defendant armed himself for protection. He could have gotten help from anyone else. There was 170 apartments about in this building. He could have knocked on other doors seeking for protection.
But since he doesn't know if he's been followed up on any of the floors, it's possible he might put himself in a very dangerous position, right? Going out in the hallway, knocking door to door. Nothing suggests he knew anybody else in the building, right?
Nothing suggests he knew anybody else in the building, but he's sitting there fearful for his life. You know, I'm a shy individual. Sometimes you might not know it, but I would go ahead and knock on a door in that situation if my life was threatened. So I think, as Judge Stein said, if you find there's a requirement, a duty to retreat, I would say that is dispositive because it speaks towards the fact that there was no lawful excuse to take this weapon. and it is consistent with the public policy and this court's precedent underlying temporary lawful protection possession, for this court to affirm the judgment, and that's what we ask.
Thank you. Counsel?
Yes, I'd like to address a few of the points. On the first issue of lawful possession, when Williams initially obtains possession of the weapon, there was a question about what is the standard of knowledge or belief. And I read counsel's brief to be saying that the question is whether Williams had a reasonable belief that he was in imminent danger, and I believe that a jury could find that at the time, in the stairwell, not looking to earlier circumstances before the possession, at the time the possession actually takes place, which counsel says is the criminal event here, a jury could find reasonably that there was imminent danger, an unavoidable conflict was about to happen, and that's precisely why the possession was lawful from the beginning. There was a suggestion that there was possession of the weapon earlier. I believe that's counsel's joint and constructive possession argument. That's an argument that was never raised at the trial court. It's inconsistent with the facts. It would have required the defendant to have dominion or control of Williams. The facts were to the contrary of that. Turning to the second point, the question of whether there was a dangerous use, I'd like to step back. The court's jurisprudence on use in a dangerous manner comes back to the Lester Williams case. And that's a case where the dangerous manner was playing with a weapon that the defendant had and had for a period of time. It was not a self-defense circumstance. So there's nothing in Lester Williams that says that perceiving that you're in a situation where you're about to be confronted with deadly force from a nemesis, as we've been calling him, Carson, who you have every good reason to be afraid of. There's nothing in Lester Williams that it relates to this case, and there's nothing in Lester Williams that prevents the court from concluding that a jury could find that the use of the weapon was consistent with a dangerous use, was consistent with lawful possession. Now, as to the surrounding circumstances point, I think the surrounding circumstances here, are that the defendant was reasonably afraid that he was about to be shot. And I think the other surrounding circumstance that the court should look at is that the defendant, a jury could reasonably find, was trying to escape to a place of safety. The way that he was going to do that was that Foe, at the point that he received the weapon, was leading him outside of the building. Foe was headed in that direction. He said, "Follow me," and opened the door. And under those circumstances, Williams could reasonably believe, again, that he was in imminent danger, and that's consistent with temporary lawful possession. Returning the gun to Foe.
Counsel, can I just ask you one question? I assume you will agree that the original intent of this statute was to, or at least one of them, the purposes, was to encourage people to turn in weapons that have been, are illegal weapons. How would finding defendant's entitlement to the charge here further that purpose?
Well,
what circumstances would promote that?
Your Honor, I think there are a few different purposes to temporary lawful possession. It's a judge-made doctrine. It's a doctrine that recognizes that there are a number of public policies, including the policy of self-defense, that sometimes are consistent with possession of an unlicensed weapon. And there are numerous cases that have held. The first department in Bonilla, the second department has several cases persuasively holding that if disposing of the weapon is consistent with the manner in which the weapon is received, that can be consistent with temporary lawful possession. I would also like to respond to counsel's argument that this was concealment of the weapon. I think a jury could easily reject that position. Concealment might have been if Williams took the weapon and took it home with him and disposed of the evidence. Some of the cases involve throwing, a weapon in the trash or the sewer system. This is a case where the gun was received from its owner. Counsel characterizes that as a co-illegal possessor. That's certainly not something a jury would be required to find. I think there's hardly any evidence in the record of that. And it was returned to its owner as soon as Williams had reached a place of safety. and it's not concealment. The owner stays on the scene. So the fact that the police don't recover the weapon, the police apparently don't investigate and search Foe's apartment, that's on the police. That doesn't mean that Williams concealed the weapon. So, and the other thing I would like to point out is, the argument that went to the trial court, the one argument that was preserved at the trial court was the argument that at the initial time of possession, the possession was unlawful because, as counsel reported at the trial court statement, the defendant had no way of knowing whether Carson was miles away. I think the defendant had many ways of reasonably believing that Carson was in the lobby, as he actually was. A jury could easily find, based on a reasonable view of the evidence, that that was consistent with lawfully accepting the possession at a time of imminent danger. And for those reasons, Your Honor, we would ask the court to reverse and direct a trial with an appropriate instruction.
Thanks, counsel.